Well, welcome to this seminar, which is a hybrid seminar. My name is Stephanie Harrison KC. I'm a barrister practicing in Garden Court, and we have convened this particular seminar in order to really see about people's involvements and understanding of what's likely to take place and whether their organisations or individuals should participate in and what they can expect to happen if they were to do so in what's been described as the Grooming Gangs Inquiry. The headline of the seminar is what campaigners, victims, core participants and NGOs need to know. So we're going to give you what I hope will be more than a snapshot, but will be the nuts and bolts of what an inquiry involves and why an organisation and individuals may want to be involved, how to influence the terms of reference of an inquiry, what is the role of a core participant and how to make effective applications, and what your rights are as a core participant, either as a legal representative or as an individual or NGO who has that status, what the funding regime is, and how to traverse what can be a challenging issue is costs and therefore effective participation. All of which is within a framework of the Article 2 and 3 of the Convention, which sets out strong protections, procedural protections for those who've been subject either to death for which a state may be responsible or to abusive mistreatment, inhuman or degrading treatment. So that's the legal framework. We're going to also hear about some lessons learned from other relevant inquiries and how it may be that we can seek to ensure that this inquiry doesn't follow the consequences or the format of other inquiries where reports sit collecting dust on shelves. And that is the important context of this particular inquiry. It's called Grooming Gangs, and in some respects that hides what this issue is about. It's systemic failure of the state to identify, protect victims of extreme systematic abuse, women and girls, and also to prosecute and ensure accountability of the individual perpetrators, and much focus is on the individual perpetrators here, as opposed to state failure to take what steps are necessary to ensure that that abuse did not occur in the first place, but when it did, that there was prompt and effective remedies in terms of criminal proceedings and other forms of methods taken available to the state to ensure that this didn't happen again. We know that this particular inquiry has been the subject of intense political debate because a focus has been about the race of the perpetrators. And I think one of the important things, which is not to say that that's not an issue, but it's not the primary issue. And it's really important for this inquiry to make sure that it puts the victims at the front and centre, because there are common issues here. The common issue with other experiences of systemic failure to protect victims and to prosecute perpetrators is not the race of the perpetrator, but the gender of the perpetrator and the failure of the state to protect. So in that context, we thought that this was a really important topic to have this discussion about. And so what we're going to do is to hear first from my colleague, Allison Munroe KC, who many of you will know is a barrister at Garden Court Chambers. She has extensive practice in family and public law, in inquests and inquiry, crime and mental health. Her work is wide-ranging, and that gives her the skill set and knowledge and expertise to have been counsel in a number of important inquiries, including the Hillsborough inquests, also for the bereaved families in Grenfell Tower Fire Public Inquiry, acting for survivors and residents. And Alison is going to talk first of all about the nuts and bolts of a public inquiry, why an organisation would want to be involved, and what does the function of a core participant mean? What's their role? What are the applications you made, and what are the rights, and how do you influence the evidence and the decision making, the investigation of the inquiry? So I will move over to Alison and hear what she has to say.
Thank you very much, Steph. Good afternoon, everyone. I'll start by giving you a quote. Barristers always do this in talks, always start with a quote. But I like this quote. It's from Maya Angelou, one of my favourite writers, African-American woman, poet, author, actor, all-round amazing woman. And she said this, talking about history and historical context. History, despite its retching pain, cannot be unlived, but if faced with courage, need not be lived again. I thought that was quite apt when one talks about inquiries, because as Steph has alluded to, public inquiries are supposed to, if they're done with candour and if they're conducted in the correct way, are supposed to uncover practices that have gone wrong, things that have gone wrong, a disaster, etc., to shine a light in areas where things have been perhaps covered up before, and to provide us, quote unquote, with lessons to be learned. Now, if I had £1 for every time I heard the word lessons to be learned in Hillsborough, during the Grenfell fire inquiry, during the COVID-19 inquiry, which we've recently finished, I'll be quite rich, actually, I think, because everybody says it time and time and time again as a mantra, but it seems that it doesn't actually stick in their heads at all. It's interesting that the number of inquiries, public inquiries convened, has risen exponentially over the last few years, with a shift as well for them being longer in terms of their form and their investigation. So just very quickly, because I know we've got a online and in person, there are some people here that I know, some people online that I know that have been very, very heavily involved with a lot of public inquiries, others haven't. So I apologise for how I'm going to pitch this, it's going to be quite general. But in terms of what a public inquiry is and what it does, a public inquiry it's set up by the government. It's a statutory inquiries are run according to the rules of the Inquiries Act 2005 and the Inquiries Rule 2006. Now, public inquiries are always established by a government minister, but once established, they are allegedly independent of government, and you have your chair, and sometimes you will have assessors who will sit with the chair, and they're supposed to be independent. A public inquiry by its nature is inquisitorial. All parties are, again, allegedly, there to examine the facts and find out exactly what happened. And an inquiry will make recommendations. The chair, and if sitting with assessors, will produce reports. And those reports are supposed to set out for the wider public, very much with the wider public in mind, what went wrong. Now, public inquiries tend to take on a life of their own. And just looking at the last two that I've been involved with, and Thalia and Stephen, who you'll hear from shortly, were also involved with these inquiries. They're very different. And in a way, that depends on a number of things. The chair, because, as I said, they are independent of government to an extent, although they're all political. But they're independent of government. And the chair very much dictates the tone of an inquiry. You'll have the terms of reference. Thalia will talk about that in a moment. But the chair is incredibly important. But also really important is who's going to be counsel to the inquiry in that team, because you can get a very different inquiry depending on who the chair is and who counsel to the inquiry are. Whether they are open to the court participants and their lawyers interacting, whether you have a good working relationship with them, or whether or not, and this is why I think they're also very, very political, whether or not they are there to control the narrative, which I think sometimes, quite often, is what's happening in an inquiry. You are told that this is going to be wide-ranging. You are told that the court participants are going to be front and centre, but actually they're political and they're politicised. And quite often it is about controlling the narrative and the report that comes out eventually. And how would you do that? Well, you do that by controlling how the questions are asked and who's asking the questions. So it's a really important, and I can't stress this enough, how different an inquiry can be depending on who's the chair and who's CTI are. And indeed, whether or not the panel or assessors are sitting with the chair, because that can make a huge difference as well, both in terms of how the chair behaves, because then they've got two other people almost sort of checking their homework and looking over them. But also it gives you obviously a wider and more diverse spectrum of opinion and thought that goes into questions and answers and how the inquiry actually operates. But they are very organic things. As I said more than once now, they are really political, and the Grooming gangs inquiry is going to be incredibly political and politicised. It already is. And I think that the chair, CTI, the core participants and the lawyers for the core participants are going to have their work cut out dealing with this and dragging it back to what it should be actually about. Steph has set out, it's about state failings of vulnerable children. And this isn't new. This didn't happen only in the north of England in the 90s or in the 2000s. The state have been failing vulnerable children for decades. The care system, social services have been failing for decades and decades and decades. And nobody actually cared about those young girls at the time when they were being groomed. I didn't see it in the newspapers, anybody complaining and jumping up and down and saying, why are these children out on the street? It's 11 o'clock at night. I've just been past a chip shop and I've seen a load of 12-year-old girls in there with adults. This happened then, it happened before, it's been happening subsequently, it's happening now in parts of England. There are children in care who no one actually cares about, who are leaving their secure accommodation or leaving their foster placements, staying out all night, absconding, and nobody seems to bat an eyelid. The police are called, the children may be picked up later on. Their own parents, there's questions, well, why were they not with their parents? Because they've been removed from their homes. There are so many other issues underlying this, and yet it's been boiled down to race, and it's been politicised around race. And it's interesting that some of those right-wing organisations are already hijacking this inquiry. Reform have been issuing opening statements. Really? That's weird, seeing how the inquiry hasn't actually opened yet. And I didn't know that Reform were going to be CPs in the inquiry, but they're happy to do that. And, and it's quite sickening to me watching it, because there are victims who are now adults who, to my mind, are being groomed by these political parties and being used by these political parties for an agenda. And these men, and they are men in Reform and pick-me women in Reform, they don't actually give a damn about these victims because their voices weren't heard at the time. There was a previous inquiry and it didn't go far enough, but their voices weren't heard then. It's politically expedient for them to be involved, and that's why they're doing it. And I think we have to be really clear, and the chair and those involved in the inquiry are going to have to be really clear about this as to what the purpose of this inquiry is going to be about. Now, core participants, they are supposed to be, as I said, front and centre in inquiry. The inquiry is there to give them a voice. So, again, each inquiry is slightly different. Each inquiry has its own protocol. For example, I was just looking this afternoon in readiness for today's seminar at the protocol, the core participant protocol that we used in the COVID inquiry. It's still online, it's on their website. All the inquiries now certainly have their own websites. You can go on them, you can see the terms of references, you can see the protocols for core participants, how to apply, etc. So there's a lot more information available now for these inquiries. But it's interesting looking at the COVID inquiry, and it says, of course, that core participant status may be granted to an individual, group of individuals or entity under Rule 5 of the Inquiries Rules 2006. And those designated as core participants will be provided with electronic disclosure of evidence relevant to the subjects, have the right to make opening and closing statements, have the right to suggest lines of questioning to be pursued by counsel, and have the right to apply to inquiry to ask questions of witnesses during a hearing. So these are similar protocols will be set up for all inquiries, but just to give you a general sense of what a core participant will do. And of course, it's obviously advantageous if you are an organisation that has been directly involved, or you have clients who've been directly involved or impacted by the issues under consideration by the inquiry. It's of course advantageous for you to try to apply as early as possible for core participant status, because as I said, it gives you that opportunity, potential opportunity to be directly involved, to ask questions, to be legally represented. Look at the terms of reference and look at the protocols to see the inquiry's approach to core participants. As well as, the usual making opening and closing statements, being involved in the Rule 10 procedure for asking questions, being able to see the evidence via disclosure and the draft report before it's published, etc. One of the most important aspects about being a core participant, I think, is that you can, in fact, if you are bold enough in terms of your representation, and if you are determined enough, you can actually help to steer the narrative if it's going in one direction, to try and bring it back to another, because you do that through the questions that are asked. Again, each inquiry is its own beast, and some inquiries, again very much dependent on CTI, will be quite open to having core participants via their representatives ask questions directly. We saw it in the post office inquiry, and it worked really, really well, because people were able, advocates for different groups were able to stand up, look the witnesses in the face, look them in the eye, and put those questions directly to them in the way that their clients, those core participants, wanted those questions put, and to ask the follow-up questions, which are often the most important ones. So you get an answer, but then there's the follow-up and what you get from that. That worked really well. In COVID, we had a system, and I know there's some of the solicitors who were involved in COVID are online, and they will probably know far too well what I'm going to say next. We had a system whereby questions were written out. It's a really cumbersome, labour-intensive system whereby you'd get, CTI would produce an evidence pack of the statements from the witnesses that have been disclosed. But then disclosure was always late. So I'm not exaggerating. We are still getting disclosure for modules that we did about a year and a half ago on COVID now. We're getting emails saying the next tranche of disclosure for module 4 is, and you're thinking, that ship has sailed a very long time ago. But CTI would produce these evidence packs from which we would then have to write out questions, submit them to CTI, who would go through them, decide which questions were worth asking and which weren't. The chair would then say, right, you've got 5 seconds, well, I'm exaggerating, 5 minutes, 10 minutes, sometimes if you're really, really lucky, 20 minutes to ask, and they'll tick off which questions you can ask. So if you had a longer period of time, you'd be getting into your questioning, doing your follow-ups, and then you'd be like, your 20 minutes are up, sit down. If you had 5 minutes to ask questions, it was almost pointless, because you'd get, by the time you'd ask the actual question, your 5 minutes is up. So that was really, it was quite, I found it quite restrictive in terms of whether or not the questions that are core participants, and I was representing COVID bereaved families for justice, whether or not our core participants were really getting their questions put across. It was because that's a huge group, and they were really involved and interested, and a group of people that wanted and had a raft of issues that they wanted to put, and it was quite restricting in many ways. Grenfell, we also had to put in questions, but it was a less cumbersome, looking back at the time. Thalia and I didn't think so, but looking back, it was actually a much less cumbersome exercise, because we literally just wrote down our questions, gave them to CTI, and we developed quite a good working relationship with them ultimately, so that we could say, so this question really has to be put for the following reasons. And, 9 times out of 10, they would agree. They would, literally there were times when counsel would be on their feet and you'd email them saying, and what about this? Ask them this, and they would. And that was again down to the nature of CTR was very different, and the chair was very less involved in that process, so it worked out okay. And we did have a whole module to ourselves, basically, where we then presented the stories of each of the bereaved, because that inquiry also had the function of, had to look at Article 2 and satisfying that inquest function as well. So again, that was very different. So in terms of being a core participant, it can be at times frustrating, but ultimately it is really vitally important that if you think, looking at the terms of reference, I, as an organisation, or my clients potentially are going to be impacted by this, they have something to say, they have something to add value to this inquiry, they need to be heard, then it's vital to make those applications, look at the how to make the applications as powerful as possible. As I said, look at the actual website and look at the terms of reference to give you an idea of how to make those applications, and to make those applications as powerfully as possible. It's important that you take advantage of that. It makes it easier, ultimately, for your organisation, as I said, to have some sort of influence on the ultimate outcome of that inquiry, not just in terms of the questions, but in terms of the report and what that inquiry is going to say. And for something, as I said, as politicised as a grooming gangs inquiries, I think it's even more important that one thinks about who are going to be the core participants. Because there are going to be, unfortunately, some very loud voices, I think, within and outside of those hearing rooms. And, it's really vital that organisations that represent, this is just from my personal point of view, organisations that represent women, organisations that represent children, organisations that know about the fact that the care system is falling apart and it's not fit for purpose. Organisations that know that violence against children and women is not something that is restricted to one ethnic group. I'm sorry, it is, it simply is not. Men of all colours at different times in histories have been violent and abusive to women and children. And we have to, almost as a mantra, remind people of that, because it's going to be so easy for this inquiry to be derailed and the focus lost. And of course, what's the other important and, in a way, sad thing of modern inquiries is that, to a large extent, modern society, things are played out on social media. And this will be such an instant here, because we've seen it already. It's an echo chamber, social media, but it's there. And unfortunately, journalists have become so lazy. So the BBC is supposed to be our national broadcaster. They'll send. It was a time we had it in Hillsborough. We had dedicated journalists from the BBC, like Judith Morris, who was there every day. We had really good journalists from The Guardian, like David Conn, who was there most days. And they produced proper journalistic reports. They were proper journalists. Now, what happens is you might be lucky to get the odd maverick who's still a journalist. On Grenfell, we had Rag Mastel from ITN, he came every day, and Sangeeta Maisco used to come very often as well. But now what you get instead is that somebody will look online, see what's, some loudmouth online who's got, 20,000 followers has said X, Y, and Z. Therefore, I'll quote that. And that one person who said it, and might have had, 3 people liking him or her, and 70,000 people saying that's nonsense, then becomes the soundbite that then finds its way onto the BBC website or the ITV net website, and finds its way onto the news, and onto all these newspapers, because people aren't buying physical newspapers, they look online for the Daily Mail or even the Guardian and all the rest of them. They all do it. It's really, really sad indictment of the standard of journalism in this country these days. It's so often sound bites are taken from the internet. So that's another reason why I think this inquiry, it troubles me for so many reasons, because of not just issues about it being derailed, but also the fact that how it's going to be reported and how that is then going to be translated to the wider public who are not going to be watching online on the YouTube channel, following the evidence every day. People will get, again, little sound bites of information as to what's been happening. So do look at an early stage, now, for that legal for that court participant status, to give your organisation and your clients that effective voice and effective participation. The other thing, and Thalia will talk about this more in due course, is of course about legal representation, and I've touched upon, as a lawyer, the sort of things that you're going to be involved with, the nuts and bolts of being a lawyer, an advocate in an inquiry. There is a huge amount of disclosure that people have to wade through. And, from my experience, I'm very lucky that the inquiries and Hillsborough as well that I've been involved with, I've had some fantastic lawyers and fantastic paralegals who have done the crunching, who have done the hard grind. I'm not going to name them all in an Oscars type speech, but you know who you are, and some of you are here and some of you are online. I love you dearly, and I wouldn't be here without you. But they do, and it is incredibly hard, because we're all legal aid lawyers. So unlike CTI, who will have their two silks in court and some juniors sitting behind them, and then a whole cottage industry of lawyers in another room working night and day, you will have yourself. You might have some paralegals helping you in counsel, and we will, we're much smaller teams, and we're having to deal with, try and get on top of all that information, all that disclosure, deal with the questions, take instructions from our clients. So it is a real challenging job, but it's so, as I said, people rise to it. Those who have been involved know, and those of you who haven't been involved, and perhaps the grooming inquiry is going to be your first one, don't be overwhelmed. You will rise to the challenge, you will. But it's going to be tough going. Finally, just in closing, can I just say, in terms of legacy, again, public inquiries all want to have their own legacies at the end of them. It's interesting that you look back at inquiries, you don't remember necessarily what the inquiry is about, but you know the names. People know the Stephen Lawrence inquiry, they'll know the Colombier inquiry, but they'll not necessarily know what the details were or what they actually did and what the recommendations do. And inquiries do tend to end up being known by the names of their authors or their chair people. But as we've said, the question of legacy and what an inquiry can actually do, lessons learned. It's sad that lessons are not learned. Grenfell produced, and I had the figures here, stats were, the inquiry ran from the 14th of September 2017 to August 2022, 7 years from the tragedy to the final report. Phase 1 ran to report 856 pages. Phase 2 report 1,700 pages. The inquiry heard from over 1,600 live witnesses, disclosed 320,000 plus documents, held on more than 300 days of public hearings. That's a lot. Yeah. And yet, what have the government done to implement the recommendations? The recommendations were good. They didn't necessarily go as far as some of us would want, but by public inquiry standards, those recommendations were good. There were 58 recommendations. What has the government done about them? Very little. They're being kicked into long grass. And now, of course, we've got the government fighting for its, the Prime Minister fighting for his life because of Mandelson and all that nonsense. On his head be it. So, you've made a rush for your own back here, Starmer. There you go. But, one was hoping that a Labour government would seize these recommendations, because in opposition, of course, it was all about, attacking the building regulations and how they had failed and how Grenfell was an avoidable disaster, blah, blah, blah. But then when the recommendations have come along, they haven't been implemented. And that is where things fall down time and time again. It's a failure of governments to implement recommendations. And that is something that we don't want to happen again. with this inquiry. So I think part and parcel of the job and the responsibilities as the lawyers, but part and parcel of being a core participant is not simply what happens in the hearing room and the questions that you ask and the report being issued. It's being involved thereafter and still campaigning to see the implementation and see effective change. I've gone on far too long. I'm going to stop now, so thank you very much.
Thank you. So we can take questions at the end and have a discussion. But what I was proposing we'd do now is hear from Thalia Maragh, who, like Alison, is also a barrister at Garden Court Chambers, who has a wide-ranging practice covering crime, inquest, and public inquiries. She also has acted in the COVID inquiry, acting for the bereaved families, and also in the Hillsborough inquest, the Grenfell Tower inquiry, the Manchester Arena bombings inquiry, as well as also the related inquiry into child sexual abuse. So has a wide-ranging expertise in working within public inquiries. She is in fact a member of the Justice Working Group on Public Inquiries, and may be able to give us a little bit of an insight into what they've been identifying in terms of their work, and focusing in particular on how to achieve racial justice through inquests and inquiries is part of her work too. In this part of the presentation, she is going to look at the terms of reference, how you might be able to influence them, and then how that would play into your role as either as a legal representative, the funding that you may get, and how that's applied for, and her experience of that from the wide-ranging number of inquiries that she's been involved in to date.
Well, thank you very much, Steph, and thanks also to fellow panel member Allison, who you've just heard from for her contribution to the discussion this afternoon. We'll, of course, hear from another colleague, Stephen Simblet, who will pick up from me. I'm going to focus on the terms of reference of a public inquiry, and in particular, the terms of reference, the draft terms of reference of what we've been describing as a grooming gangs inquiry, and also look at the topic of funding for core participants and legal representatives for core participants in a public inquiry. Now, one of the challenges, as Alison pointed out, that core participants face when you're involved in a public inquiry is actually getting your questions asked by the inquiry. And that's all dependent, as she's pointed out, on it boils down to the personalities quite often of who is counsel to the inquiry. But before you actually get to the inquiry room, the critical stage is setting the terms of reference of a public inquiry. And having been involved in Grenfell from pretty much the outset, I have to say, certainly in my experience, Grenfell represents a success of a community in influencing the terms of reference of that inquiry. And what I propose to do as a part of my presentation towards the end is to play a clip that was prepared. It's just about a minute long, but it was prepared by members of the community and disseminated. I know Alison has spoken about, social media, but it was disseminated over social media. And it really was just telling people what is a public inquiry, the importance of the terms of reference, and the importance of effective participation and participating in that consultation period. And, quite often, consultations, whether it is for planning, whether it is for public inquiries, the consultation period is publicized, it's on the website, but it's not usually long. And as I will demonstrate in my presentation, I don't think the consultation period for this, the terms of reference for this public inquiry is particularly long, but you can judge for yourselves, those of you in the room and those online and those who will pick up or recording in due course. Now, just to set the scene and to give ourselves a timeline on the grooming gangs inquiry. So following the Prime Minister's announcement last June of a national inquiry into grooming gangs, on the 9th of December last year, the Home Secretary announced to Parliament the appointment of the chair, Baroness Anne Longfield, former Children's Commissioner, and two panel members, and also its draft terms of reference. And the key here is draft. And you've got the timeline, 9th of December. And as Allison points out, inquiries these days have their websites. The Grooming Gangs Inquiries website is not effectively up and running, but the key documents are available online on the government website. So you can get the draft terms of reference, decisions made about appointment and consultation that I'm going to come to from the government's website. Now, as Alice alluded to, the setting up of the inquiry's terms of reference is a crucial step in the process of an inquiry because it is the terms of reference that will determine what the inquiry's scope of investigation will be. Effectively, the matters that are to be investigated. No, we're not. No. I'm going to use a couple of slides, but just for emphasis, and I will get to it in a bit. And as I've pointed out, the terms of reference is one of the pillars of a public inquiry, and the significance of that and the scope in legal terms is set out for the lawyers in the room and online at Section 5 of the Inquiries Act. And the critical features, the terms of reference must include the matters to which the inquiry relates, any particular factual matters that the inquiry panel is to determine, whether the panel is to make recommendations, and this is a sort of catch-all term, any other matters relating to the scope of the inquiry that the minister, so in this case, the Home Secretary, may specify. Now, ideally, the terms of reference should set out in clear and unambiguous terms, because remember, it's effectively the root of it's a backbone of the inquiry. In clear and unambiguous terms, the events or actions which the inquiry will investigate, addressing the fundamental issues that have given rise to the inquiry, what, if any, other matters will be examined or not examined, the organizations and agencies that will be investigated, and critically, a target date for the inquiry's completion. And as I've said, the inquiry has no power to act outside the terms of reference. But critically, the minister may, after consultation with the chair, amend the terms of reference if it is in the public interest to do so, all right? And that again is provided for in the provisions of the Inquiry Act. Now, effective participation. I mean, it's no good for you to have an inquiry where the people who are impacted, the victims, are sitting like bystanders, and people are making decisions without their participation. And of equal importance, right, is effective participation in the setting of the terms of the inquiry. It's no point in there being draft, promulgated, it being finalized, and those who are impacted, and I come back to the victims in a public inquiry, because, in my view, it is the victims who usually call for an inquiry, usually call for that investigation. It's no good if the ordinary individuals who are disenfranchised, who are affected by the matters being investigated by a public inquiry, have no say in the consultation, have no say in the finalizing of the terms of reference. So turning now to consultation, because consultation is an important tenet of effective participation, right? Now, coming back to the website, because everything is online, The Grooming Gang website updated. So we're talking about the timeline here. The announcement is made on the 9th of December. By the 11th of December, the draft terms of reference is put up on the website. And for those in the room and those online will get a copy of the draft terms of reference. And it's on the government website. For those in the room, we've printed off a copy of the draft that we've downloaded from the website for you to just have a look at as we go through the draft terms of reference and make an assessment for yourselves as to whether you consider it to be adequate or, the extent to which there needs to be input through consultation. So on the 11th of December, the draft went live and it announced that there would be consultation on the draft and more information will be provided on this in January before the finalizing of the terms of reference in March 2026. So here we've got, announcement in December, Christmas intervening period, more updates going to be given in January, and then the closing is going to be of consultation, finalizing of the terms of reference is going to be in March. Now, the text read as follows. The chair will consult on the draft terms of reference and will provide more information in January. The final terms of reference will be agreed with the Home Secretary and will be published by March when the inquiry will be formally established. Now, December, January, we're going to be given an update. Well, the update seemed to have made its way to the website on the 10th of February. With information on the consultation period that it ends on the 31st of March 2026. And as a part of the consultation, there is limited time. So you see, I'm talking about effective participation here. I'm talking about, the public's ability to participate in the consultation, to shape the terms of reference, which is the pillar of the public inquiry. But what are we seeing? We're seeing a shrinking of the period here. And you can judge for yourselves the scope of effective participation here. And so as a part of consultation, there's a limited time to participate in online consultation survey, which closes on, shrinking the time even more, the 6th of March. So it's going to be finalized on the 31st. But there is the announcement on the 10th on the website that you've got until the 6th of March to participate in this online consultation survey. And this is where the...
Were you affected by the...
No, not that yet. So this is what I took from the consultation site. And on page 2, it sets out in brief terms what the inquiry will look at. So you've got the bullet points, it will focus specifically on group-based sexual exploitation and abuse carried out, but what is commonly called grooming gangs. It defines more or less what is meant by child exploitation, and it sets out what this can include. If we could just go to the next page. And it speaks about the terms of reference, and it notes that, or advises that at this stage, the consultation relates specifically to the draft terms of reference, and it's not wider than that. And then it notes, and this is what I have highlighted, the consultation survey will close just before midnight on Friday, the 6th of March. Now you ask yourselves, right? To what extent is this publicized? How many people know that there is this consultation period that has gone live, and 2, that it is for a limited duration? And for those in the room and for those online, I invite you to go on the website that we've provided the link to, and assess for yourselves how open it is to effective participation. Because I can tell you, I did try to go through, and it's click next, and you're thinking, well, actually, is this more prohibitive? And what of people who are digitally excluded? What of people who, are not open to engaging in online consultation of this nature? Ask yourselves, is this sufficient time for people to effectively participate in the draft terms of reference? Knowing knowledge is power, and we ask ourselves, how many people, how many real victims, and as Allison pointed out, this is a highly publicized and politicized, not publicized, politicized inquiry, and people who are victims will be exploited for political advances, and so there needs to be openness. There needs to be, ask yourselves, is this sufficient engagement with the people who are really affected? Turning now to the draft terms of reference. Next slide. The draft terms of reference sets out 4 topics. The overview, or 4 headings: the overview, victim and survivor focus, grooming gangs, purpose and objectives of the inquiry, the scope of the inquiry, governance, and recommendations. And there are just a few features that I would want to expand on in the overview, on these headings. The overview. And the overview sets out that the inquiry is in response to Baroness KC's review, as we know, and it proposes to identify failures in practice and to hold to account the individuals and institutions responsible for these failures. And in terms of a geographical remit, it will cover England and Wales, and it will work in close collaboration with police. It is said that the inquiry, the terms of reference, the victims and survivors must be at the forefront of the inquiry. How many times have we heard this on the announcement of a public inquiry? And the victims and survivors are often, they're often clamoring for their voices to be heard, for their real issues to come alive. So it's really important for this inquiry to really give a real voice to victims and survivors. Grooming gangs, it specifies that the focus of the inquiry's work should be group-based, should be on group-based child exploitation and abuse. Purpose and objectives. It sets out that the investigation will include local and investigations and national review, looking at the current practice in tackling grooming gangs in local areas and across the country and the role of national government, identifying institutional and individual failures and making recommendations. Scope includes the definition of a child as anyone under 18, but will include the exploitation of individuals over 18 where abuse started under 18 years old. And the inquiry's investigation, as I mentioned, will cover England and Wales, and the period of investigation will span January 1, 2020 to the date of the setting up of the inquiry. Governance, well, we know a chair and 2 panel members has been appointed. And there's also provision for the appointment of assessors or advisors to assist the chair and the panel with its work. And in terms of recommendation and reporting, the time frame for reporting is 3 years. Stepping back, ask yourselves, is this sufficient meat, as it were, to the bones of the terms of reference? And this is why it is so critical for there to be participation in the consultation and engagement in the consultation period, to ensure that the interests of victims are truly reflected in the scope of the investigation. Turning now, if I may, to the other topic which falls within my remit for discussion, and that's core participant status and legal representation. Allison went through who is a core participant, and the participation of core participants in a public inquiry. And I'm just going to touch a little bit on funding, because victims often constitute, and the vast number of core participants in a public inquiry. And one of the immediate questions that a layperson, the ordinary person who finds themselves a victim of violation, a victim of abuse, who falls within the scope of core participant status, one of the immediate questions that ordinary people ask themselves is quite often, how do I get legal representation? Or equally, how do I afford legal representation for a public inquiry? And the Law of the Inquiry Act makes provision for the chair of the inquiry to make an award for reasonably incurred expenses or compensation for loss of time, where the individual attends the inquiry to give evidence or to produce documents, or has such an interest in the proceedings or outcome of the inquiry to justify an award being made. The chair also has the discretion. So this is an award being made to a CP or a witness attending an inquiry. Now, the chair also has the discretion to make an award for funding for legal representation. And the exercise of the chair's discretion in making an award for funding will be balanced against the need to avoid unnecessary costs, which is set out in the Section 57 of the Inquiry Act. And there is a real tension between the award of funding, interestingly, for legal representation and the need to act in such a way to avoid unnecessary costs. And whilst, in my experience, the inquiries that I've been involved in have funded the legal representation for vast majority of victim core participants, there are, in a number of instances, in my experience, funding awards not being made to groups, particularly, organizations that represent the interests of victims, where it is believed that the organization is sufficiently funded or has sufficient resources to fund its legal representation. In my view, there have been times when I believe that it's caused an injustice, particularly to grassroots organizations representing vulnerable people. And one of the cases, the case I've referenced, which was an appeal, a judicial review brought by the Travelers Movement, challenging the decision of the chair in the COVID inquiry to refuse the application for funding for legal representation, is one such instance where, in my view, the award should have been made because the travelers community was disproportionately impacted by COVID, and the organization, in my view, had a legitimate space, had legitimate issues to raise on behalf of the travelers community. And what ends up happening is that an organization acts pro bono, and as Allison says, you need to be pouring through, thousands and thousands and thousands of pages of documents. And what may happen is that that organization is not able to give the victims the support through legal assistance that it needs. And the essence, really, of the decision and the not to grant funding to the organization is set out in paragraph 7 of the authority. And I'll just quote it for the lawyers in the room and online, because I think it's a really important consideration that you really need to bear in mind when you are representing, or you've got potential clients that are organizations. It may feed into the advice you give around application for CP status, or how that organization approaches the inquiry. And what the court noted was this: in the ordinary course of events, public funds are not to be expended on providing legal representation to bodies whose size and resources are such that, Other things being equal, they ought to be capable of funding themselves. And it considered that the test was the determination of whether or not the organization constitutes a substantial body. So those are some of the points that I wished to expand on or to highlight in my presentation to you. And just 1 minute, before I wrap up. As I indicated when I started, I really, pay homage to the Grenfell community and their resilience in coming together and engaging in the consultation. And what they did, as I mentioned, was to do this recording, on what is a public inquiry, what are the terms of reference, and why you should be involved. It's on YouTube, and so I would just like to share it with you. I don't know if those online are able to hear it. Yes, okay, so that's fine, but you won't be able to see it. And it's really simple, and it's really an example of ordinary people coming together to mobilize, a community to engage in consultation. And I commend that to the victims of this inquiry, so that you're not used for people's political gains, but you are empowered to engage in effective participation. So if we could just play the recording.
Were you affected by the Grenfell Tower fire? Act before the public consultation closes on the 4th of August. The government has set up a public inquiry into the Grenfell Tower fire to investigate what happened and to prevent a similar tragedy. What are the terms of reference? It defines a scope of the inquiry, and the inquiry can only investigate matters covered by its terms of reference. It sets out what the inquiry is about, what events and actions need investigating, who or what organisations need investigating, and what should be changed for the future. Why participate in the terms of reference consultation? If the terms of reference are wide in scope, it means that more issues will be investigated, but a narrow scope might ignore certain questions people have asked, like how the council and the TMO's behaviour contributed, how and why the cladding came to be used, why were people's concerns about safety ignored, were people discriminated against, why was the authorities' response to the fire such a failure. Have your say about the scope of the inquiry as well as its format. Do you want a panel as well as a judge? Who should be on that panel? Would you like to ask questions directly? Who can participate? Anyone directly affected by the fire, as well as local residents, volunteers, anyone with strong views on why it happened, anyone with information. Submit your views before the 4th of August. How to participate? Respond direct or via a representative to the inquiry. Email contact@grenfelltowerinquiry.org.uk or by post to Grenfell Tower Inquiry Team, Royal Courts of Justice, Strand, London, WC2A 2LL. Each voice makes a difference.
Each voice makes a difference. Thank you. So we hand over to Lisa.
Yes, thank you very much. So our last speaker is Stephen Simblet KC. He too has a wide range of experience that have focused on civil claims against the police and public authorities, as well as inquests. He has a specialisation in mental health and court of protection, public law and judicial review. All of that expertise he's brought to bear as counsel involved in a number of public inquiries, some of which in common you've heard from Allison and Thalia, the Hillsborough inquest, and one particular inquiry that he's going to talk about and to give us his insights into how that worked and how it could be improved was the independent inquiry into child sex abuse. He appeared there for different forms of core participants, both a local authority, Nottinghamshire councils, acting also for accountability and reparations phase, and in the Lambeth Council phase. So that had different elements to it in which he was instructed on behalf of survivors of child sex abuse in those three phases. That was one of the most longest public inquiries, and in some respects, it's the failure of that inquiry's recommendations to be implemented, which has resulted in the need for this further inquiry. Stephen's going to speak to us online, so here he is.
Right, hello everyone. Sorry, I'm being beamed in from abroad. I probably look like Zordon from Power Rangers coming on your screen there.
You wish.
But and following the shiny bald head image, I'm going to be my slides. I'm going to have to do the old Chris Whitty next slide, please, as we go through them. So, but I'll start with as Stephanie said. Can I have the first of my slides, please? The video's ruined. Oh, there we are. Right. So, I mean, as people have said, the background to setting up this inquiry, and the government was quite resistant at first, seeing it as a sort of political pressure from the right. The fact that the inquiry having been set up, is obviously an important one. Although there's some politics around whether what had happened had been sufficient and so on in the past. And the focus from those campaigning for it has been to try and frame it in terms of the of race. Really, what we need to look at is how grooming and sex abuse managed to be perpetrated and what we can do to stop it. Obviously, and I'll put this in my second last bullet point there, it's important that the inquiry doesn't look at things purely through race. I mean, we only have to look at what's going on at the moment to see that one of the biggest grooming gangs involved Epstein, Mandelson, a whole range of people round the world, none of whom are of Asian heritage in a northern town. So the whole way in which it's being framed and so on is one that we've got to try and get away from and see what actual benefit can be is used so that we don't end up with another sterile, dusty book on a shelf. My last bullet point there, I will say something about, because what people have in common in terms of susceptibility to becoming embroiled as a victim in this is a vulnerability to exploitation. Alison's spoken about a number of ways in which that arises, and if we can move to the next slide. And I'll say a little more about vulnerability in a moment on one of the other slides, I think. But the vulnerability to exploitation is the core thing that we're going to have to keep in mind when looking at how to influence this inquiry in a positive way. As Stephanie's mentioned and is in my slides, the independent inquiry into child sexual abuse was supposed to be a generational inquiry into this issue of abuse of children. And it set up a whole range of ways in which it was going to look at. There were 19 of given various examples there. I don't think we need to look at that slide for much longer, but safe to say with the bottom bullet point, one of the things that they said they were looking at was child sexual exploitation by organised networks. So if we can move to the next slide. The problem with it was that there was a sort of isolated approach. That this comes back to the theme that Allison in particular was talking about, which is, how inquiries operate depend on the personnel involved. And one of the things ICSA did was it chose this very compartmentalized approach, modules and so on, and it seemed to explore those in isolation, didn't really come up with any overarching lessons. So at the end of the process, many people were dissatisfied. There's no real consistency of approach to recommendations or any real political will to implement what they had come up with. So if we can move to the next slide. Yeah, perhaps I'd put them on. Yeah, this is my vulnerability slide. You know, the general characteristic, I'm trying to frame that into ICSA. The general characteristic of survivors and victims is that they were, and in fact, in some cases, in ICSA, were at the time, vulnerable children. Modules that I was involved in included the Lambeth Children in Care, Lambeth situation where they looked at children in care. They focused on some particular children's home, and they also looked at what may not have been very well investigated, rumours of council staff and politicians preying on children in their care. That's the sort of thing that we're likely to be wanting this inquiry to focus on, the extent to which organised networks are able to co-opt the resources of local authorities and so on, or similarly the failures of local authorities to be able to do anything about it. Quite often there's going to be allegations of police involvement, police corruption and so on, and all of that is one of the things that was supposed to be looked at in the Lambeth module. Similarly, in Nottingham, the Nottinghamshire councils, they looked at a particular children's home and also arrangements for foster care. But how they should have framed it, and how I would hope that this can be properly framed, is by seeing the focus in terms of vulnerability and how vulnerable children are going to be susceptible to people exploiting their dependence on material, on giving them material things or experiences and so on, and how their susceptibility and vulnerability to becoming, say, addicted to drugs and alcohol or other things like that at the time, without having proper support from parents or adults to look out for them. That's the core prism by which we should be looking at who the focus of, but putting, as has been said by the other speakers, putting the victims and survivors front and centre will involve properly understanding that the core characteristic is vulnerability, and how that vulnerability carries on affecting their lives now. So if we can have the next slide, please. This is really about power rather than race. And the fact that those who are vulnerable are susceptible to abuse comes about because other people have power that they are able to use against them. Can I have the next slide, please? So looking at how people were and how they're going to be now, and how we need whoever whether you're representing survivors or victims directly, or organisations that support them, or organisations that are supposed to know something about how to help and protect those people. A number of characteristics you'll need to have in mind, and they were certainly ones that in a sense, were lip service was given to some extent by the ICSA inquiry, but ultimately it was quite difficult at times for them to manage. So things like feeling ashamed, things like the problems that come from being vulnerable and in care, say, in the first place. It's damaged a person's life during their childhood at a time when they're particularly susceptible to be damaged. Often the people affected have had a disrupted education. Many of them have had sustained psychiatric damage. In fact, one of the other pieces of work I'm sometimes involved in is bringing claims against local authorities or the police or people like that for failing to protect children from being attacked and so on, and from which they've suffered psychiatric damage. But psychiatric damage isn't just to be measured in pounds and pence in that sort of claim. It's psychiatric damage that affects people's lives now, and many people may have ongoing mental health issues. It's also going to mean that people who are victims and survivors are going to be fearful or suspicious of authority. I've put not wearing suits. That comes from one of the solicitors' firms that instructed me in the in parts of the ICSA inquiry, because they were representing people who'd been abused in care and so on. Many of those people associated the men wearing suits with the sorts of men who'd abused them. So being careful to sort of understand the approach and the lives that people have lived in getting or in getting to this point and trying to support and help them is going to be important for the inquiry and for lawyers managing them. Again, also not being listened to. Often this abuse has taken place because people didn't listen to children. They didn't want to listen to them, and they certainly didn't want to listen to these sorts of children that had literally no voice because of the circumstances in which they lived. And when we're looking at what we can offer and how we should be trying to frame the inquiry, one of the things that we have to be frank about, and people who are listening in who may be directly people in this category, is to not mislead people about the extent to which an inquiry is going to listen to them in the sense of listening to their story. The ICSA inquiry had some form of listening project. The COVID inquiry had some form of listening project, but the extent to which the listening translated into the inquiry personnel actually affecting what they were going to do by reason of what somebody had told them is very much another thing. And it's important when we're trying to help and support people that to get away from the idea that merely that everybody will be able to give evidence. In the child abuse inquiry, it was noticeable. In fact, of my next slide, please, that some people felt very encouraged because they were selected to give evidence, but other people felt entirely discouraged and alienated from the process merely because their story, their account, wasn't in some way brought forward by the inquiry for them to give oral evidence. And one of the things I was able to do, and it was for the Nottinghamshire phase, is have a phase of it where everybody's story was in some way summarized and read into the record. So they had managed to have a sufficiently defined group of individual survivors whose accounts and stories were summarized and read into the evidence. And some of them were a really terrible tale, really distressing and upsetting accounts that upset, and this comes back to Alison's point about the journalistic coverage. In the Nottinghamshire inquiry, that was covered by the Nottingham Evening Post. It had a sort of running commentary of what was being said in the inquiry, and the shock and the distress in the way in which that was relayed by the journalists was really apparent. But even with that sort of attempt to be able to ensure that everybody's story was told, there were some people who thought that, as it were, they had been left out because they weren't called to give evidence from the witness box in the way that others had. And this is one of the things that can affect the way in which people who've been sexually abused and essentially should be the focus of this inquiry find it difficult to translate their suffering into the sort of lawyered environment of an inquiry, because, as Alison said, really a lot of these inquiries seem to involve just the inquiry chair and their lawyer team liaising with other lawyers who are representing core participants. And it's our job to try and get past the barrier that inquiries listening to people, formalised and lawyers monopolise. It's our job to ensure that actually people's voices are heard. Now, again, there were some of the ways in which victims and survivors had formed themselves or tried to get their voices heard was to be in survivors groups. And again, some of those, and it may, if you're approached by a survivors group, obviously that's a very good start. But actually trying to help and support the survivors group through an inquiry is something that you'll need to be mindful of. Very few of the victims and survivors groups can be as cohesive as, say, the various Hillsborough families groups. And of course, even in Hillsborough, where everybody had the same experience because their loved one had died at Hillsborough and they'd had the same sort of bereavement. Even there were different groups of families, and they didn't all want to be, or indeed manage to be, in part of one group, and that's very common amongst groups of people who've been sexually abused. Not only are there internal conflicts and so on, and the sorts of conflicts that arise in any group, some of the people involved are going to be more forthcoming, others are going to resent that, and there's sometimes internal conflicts and so on. And the inquiry itself can fuel those conflicts. And I've given an example that some people feel they've been given a voice by being given an opportunity to give evidence, others have not. Even in the way that the inquiry managed its resources. In the Nottinghamshire Council's group, part of it, one of the groups was, and it wasn't my clients were much more separated, but there was a survivors group, and within that group, people were getting sort of resentful about people being perceived as given a sort of opportunity to attend and be accommodated and given their travel expenses, those sorts of things, where they've been able to essentially be respected by the inquiry by being resourced to attend. Whereas, in fact, one of my clients who wanted to attend, give evidence, they refused her all her expenses, such that she was suggesting, well, shall I come and sleep on the floor of my van? So those are all problems that you need to be mindful of when navigating the inquiry, that the people that we're dealing with, that we actually are going to put, if we're doing our jobs as lawyers properly, at the front and centre of this, have particular needs and particular problems that are probably still affecting their lives. Can we have the next slide, please? Well, I've put what will happen, possibly very little. I don't want to be a doom monger, but I do want to say how important it is to ensure that this isn't an inquiry that just comes up with some recommendations that nobody ever does anything about, or recommendations that don't mean a great deal. It is our job to ensure that this inquiry is not just put on the shelf under the name of the inquiry chair for others to read. And if going back to the child abuse inquiry, before I get on to what's on my slide, one of the points that was very obvious in, say, what the phrase that they called the phase that they called accountability and reparations, which was looking at how people who've been have been sexually abused can seek forms of redress. One of the things that was very obvious was how many similar inquiries there had been into child abuse. There was the North Wales inquiries from the 1980s, the stuff in the 1990s, inquiries into various local authority failings, the Frank Beck inquiry, which dealt with a notorious abuser in Leicestershire and Leicester children's homes. All of these inquiry reports had essentially been in the news for a few days and then put on someone's shelf, not to be taken down until there was another inquiry and somebody wanted to open it up and see what the last one had said. ICSA hasn't yet got to that stage, but some of the recommendations were a bit limited. I mean, Nottinghamshire councils, one of the major recommendations seemed to be that Nottinghamshire, having not properly protected children from, or Nottingham City Council and Nottinghamshire County Council, having not managed to protect children from abuse properly over a very long period and not properly inquired into it themselves, should use their own money to set up other inquiries and other evaluations. Well, where did that add up to? In Lambeth councils, there was relatively limited recommendations around sort of ensuring that councillors are trained and people are vetted and recruited properly and so on. But again, these were what was being alleged in the Lambeth Council's inquiries was all sorts of organised networks and exploitation, including involving councillors preying, allegedly preying on children, and the council workers having the opportunity to prey on children, essentially children being trafficked from various children's homes in Lambeth for sexual abuse. So those sorts of, when you see how stark all of that was, to see what the limited nature of the recommendations, it was a surprise and a disappointment. The accountability and reparations, I'm only picking out ones that I was involved in, suggested setting up a redress scheme and encouraging insurance companies to adopt a sensitive approach. Well, I opened my opening remarks in that inquiry to point out how much the insurance companies had to lose, and that we're essentially dealing with people with a £50 billion industry who see their duty to their shareholders as being to hang on to as much of that 50 billion as they possibly can and not pay it out to anybody who's been abused. Can we have the next slide, please? Yeah, and again, talking about where things got to ICSA, one of their headline recommendations was that there should be a mandatory reporting obligation. In other words, that people who came across sexual abuse should be required by law to report that so that it would be acted upon. Well, ICSA finished in October 2022. We've had 4 governments since then. Nobody's yet actually implemented that. It's part of the crime and policing bill going through Parliament to impose a duty to report child sexual abuse if witnessed, personally or in recording, or if told about it. But the expectation that people would have had was this would create a criminal offence if not reported, but that's not what's proposed. The sanction is referral to the disclosure and barring service that may not even end up with that. So my sort of core message, and I won't go to my next slide yet. My core message is that if we are going to engage and make this inquiry work, we have to be particularly mindful of the failures that there have been in previous inquiries on this particular topic, particularly sensitive to the vulnerabilities of the core people involved, the people who actually have been the victims of grooming gangs, particularly receptive to how they are going to feel, and particularly directed to ensuring that the inquiry itself genuinely understands what they need from it and commits actually to something being done. Those are all of our responsibilities, and the responsibilities particularly of people who come forward to help and support core participants. So there we are. That's what I wanted to say. I think what's my next slide? I think I do have one. Oh yes. Well, I'd said pass on from that one. There we go. That's all, folks, so far as my talk is concerned.
I think we can probably leave it there. Obviously, we've heard from the three speakers that we had about throughout the significance of the role of the individual victims within and survivors within these inquiries, and identified a number of ways in which that's a major challenge, that the promise of putting them front and centre doesn't always occur. We know from case law that what is supposed to happen for victims through representation is that the indignity and the humiliation and the disrespect that they experience is addressed by being in the room, in principle, operating with a legal representative on an equal footing with the others in the space. And that is the big challenge, to ensure that that does happen in practice. Obviously, we've had a lot of contributions about the limitations of that role within the inquiry, but also how you can make a big difference. And this inquiry, perhaps more than others, the role of the core participants representing the victims and survivors is going to be critical to ensure that the narrative that has set up this inquiry is not going to dictate and override all other considerations. And finally, there is the big issue here, is about when they say lessons learned. We can learn many lessons, but will there actually be implementation? And I think probably from the outset, it would need to be said, for those who are core participants, this should be an inquiry where one of the things to understand is why lessons haven't already been learned, and to ensure that, like some inquiries, for example, the Manchester Arena inquiry had a 6-month follow-up, so that there had to be a report and a response on implementation of the recommendations. If they've been accepted, are you implementing them? That's not happened in many inquiries, but I think the House of Lords has recently investigated and come up with quite detailed recommendations for how implementation of inquiries needs to change. It will need to be on a statutory footing, because there's nothing in the Inquiries Act that deals with implementation. But at least one of the things that all core participants should be saying from the outset is that you want a period, 6 months or a year, and it may be more than one, to follow up and for the inquiry to continue with its jurisdiction to see whether actually any change in implementation has taken place. And hopefully discussions like this will mean that that those who do wish to be involved, either as participants or as lawyers, will be having that at the forefront of their minds. Anyway, can I say thank you for all our speakers, and thank you for